All right, let me welcome everyone. The government members of the committee are under a little constraint this morning. With the permission of members, I would ask that we suspend the item confirmation of minutes of meetings held and go to new business to take the presentation of the Independent Jamaica Council on Human Rights, and then we come back to the minutes. Any objection to our proceeding?
No objection, no objection.
Very well, thank you. I know the former public defender is on the outside. Please let us have her on the inside. Thank you all.
Is it possible for both presenters to come in, just so if one hears something from the other one that was already done, they don't have to do it again?
It is possible. We only have two presenters. If both are outside, you may invite them in. Usually they are not called in for space constraints, but we have no constraints on the space today.
Chair, while we wait, is it possible through you to ask the clerk for this committee when the case is to show the pronunciation reasonable suspicion, when we'll get that as requested last week? Or the legal counsel to this committee?
All right. I believe, let us deal with that after the presentation. All right, let me welcome Mrs. Arlene Harrison Henry to today's sitting of the Joint Select Committee to consider and report on the bill entitled An Act to Repeal and Replace the Bail Act and to provide for connected matters. It's now 10:24. 20 minutes, 30 minutes. Very well. Leaving time for question and answer. I invite you to make your presentation to the committee.
Once more, good morning. We want to thank the committee for allowing us this opportunity to make our comments on the bill intended to amend the existing Bail Act. Chairman, we had submitted our written response, and I trust that those have been circulated to members of the Joint Select Committee. On page 1, we include some historical detail only to contextualize our discussions today, and by recognizing that the 1962 Independence Constitution gave constitutional protection to the right to bail. And going to subsection 1 of our submissions, that remains so, and the Constitution effectively provided a constitutional guarantee to the right to bail without even using the expression bail. And it did so by simply requiring that any person who is arrested and who is not released shall be brought before a court without delay, and that if the person is not tried within a reasonable time, the person shall be released either unconditionally or upon reasonable conditions. In 2000, the Bail Act was passed, and as the bail procedures were operationalized, it later met with some criticisms from some quarters that it contributed to the level of crime in the country. In 2010, the government responded to these criticisms by passing amendments to the Bail Act, severely restricting the grant of bail for certain offenses. And in 2011, the Supreme Court of Jamaica ruled that the amendments were unconstitutional in their attempt to restrict bail. Coming forward, in respect of the Charter of Fundamental Rights and Freedoms, which received assent on the 7th of April 2011, again, Section 14(4) provides any person awaiting trial and detained in custody shall be entitled to bail on reasonable conditions unless sufficient cause is shown for keeping him in custody. Chairman, members of the committee, Section 14(1) of the Charter of Fundamental Rights and Freedoms enumerates extensively the grounds on which any individual can be deprived of his liberty. And I want to read it because I think it's instructive to the discussions that we're having. And I quote, "No person shall be deprived of his liberty except on reasonable grounds and in accordance with fair procedures established by law in the following circumstances." And I'm not going to go through the provision extensively, but I want to give some examples of the matters contained in our Constitution that could possibly justify the deprivation of liberty. And the first one is, in consequence of his unfitness to plead to a criminal charge. B, in execution of the sentence or order of a court, whether in Jamaica or elsewhere, in respect of a criminal offense of which he has been convicted. C, in execution of an order of the Supreme Court or the Court of Appeal or such other court as may be prescribed by Parliament on the grounds of his contempt of any such court or of another court or tribunal. I've not listed everything contained in the section, but, Chairman, it is advisable for us to look at section 14(1)(f), where an individual on an arrest or detention can be deprived of his liberty. 1, for the purpose of bringing him before the competent legal authority on reasonable suspicion of his having committed an offense, or 2, where it is reasonably necessary to prevent his committing an offense. The Charter of Fundamental Rights and Freedoms also provides certain important guarantees to the citizens, and it will be the position of the Council that rights ought not to be read down. I refer, Chairman, to section 14(3), which provides any person who is arrested or detained shall be entitled to be tried within a reasonable time, and A shall be 1, brought forthwith or as soon as is reasonably practicable before an officer authorized by law or a court, and 2, released either unconditionally or upon reasonable conditions to secure his attendance at trial or at any other stage of the proceedings, or B, if he is not released as mentioned in paragraph A2, shall be promptly brought before a court, which may thereupon release him as provided in that paragraph. Chairman, that is a background to our submissions. We note the advice rendered by the Privy Council on July 15, 2022, and we also note that there is no attempt by this bill to deny bail to any particular category of offenders. So, looking more closely at the bill before the committee, we notice that it seeks to a much greater extent than its predecessor did to regulate the procedure for bail, and more notably seeking, 1, to dictate extensively the factors that a judge must consider in the exercise of the discretion to grant, refuse, extend, or revoke bail, and 2, introducing in the laws of Jamaica a regime of bail after detention but before charge, in which regime the role of the judiciary arises after that of the police and justices of the peace. The memorandum of objects and reasons accompanying the bill offers 3 reasons for it, they being essentially that the existing Bail Act was enacted prior to the Charter, that there is need for greater clarity in certain provisions of the existing Bail Act, and that there is need for new provisions to address circumstances that are peculiar to Jamaica. The purpose of our submissions, Chairman and Committee, is not to go through the intended bill in a clause-by-clause fashion, nor is it intended to compare these proposed provisions with the existing Bail Act, but instead to offer some observations and perhaps criticisms of the provisions that the Council considers unjustifiable to affect the discretion of the judiciary and therefore to incur the risk of being struck down as unconstitutional or not falling within the parameters and matters allowable within our current Constitution. We look, Chairman and members of the committee, at empirical research which the Council finds missing The bill does not, at least from the material available to the Council or the public, appear to have been conceived in an environment of empirical research to establish that the discretion of the judiciary has been so unreasonably or otherwise so detrimentally deployed that the judiciary deserves to be circumscribed in its jurisdiction over bail. The exercise of the granting of bail is primarily a judicial function and duly recognized in our constitutions. We are of the view, and I think that this is established, that governments have a responsibility to govern, and the creation and provision of a safe and secure society for its citizens to live in is perhaps the most important requirement of governance. But the deprivation or derogation of judicial discretion should not be such a quick resort, where no scientific study or survey has been done to produce any statistics to even suggest that the prior exercise of the discretion is a part of the crime problem that so chronically afflicts the society. We've heard of these criticisms coming from several quarters, but the evidence and the empirical data has never been shared with the country. We regard them as assertions. The separation of powers, Chairman, members of the committee, is a fundamental principle of Jamaica's constitutional system and should be given great respect. In fact, I would say that it is one of the cornerstones upon which our democracy rests. Looking, Chairman, at paragraph 9, bail before charge. We particularly identify clause 5, where it is proposed that justices of the peace and superintendents and higher ranks of police have the first jurisdiction and discretion to grant bail to a suspect who has been detained but not yet charged. I'm sure the committee understands that this is a fundamental change because it allows a police officer or justice of the peace to restrict personal freedom of citizens who have not yet been charged with any criminal offense. This is a far-reaching jurisdiction and a discretion that we submit can only appropriately be given to the judiciary as a tried and tested, trusted arbiter between the citizen and the state. We believe, Chairman, and submit that the notion of bail before charge departs from fundamental human rights norms. This newly proposed discretion introduces a phenomenon that has commonly been described as bail before charge, and indeed it is arguable for some that the time has come for such a device to fight crime, but it is also unarguable that not even the police themselves would consider that they are impartial arbiters in this fight, just as it is unarguable that justices of the peace generally do not have specialized training or experience or possibly even the desire to exercise this extraordinary power. We submit to this committee that this device should be left with the judiciary and certainly not conferred upon any officer of the state that has a professional interest in the detention of persons against whom he is unable to prefer a charge at the time of detention or for some time thereafter. we submit that the very language of Clause 5, describing as a defendant a person not yet charged for any criminal offense but detained, is significant for the detectable bias that it contains. Prior to these provisions, such a person would be described as a suspect upon whom the common law, mainly the judge's rules and the Constitution, conferred certain rights that have become well established over the years through constant judicial scrutiny and application. But the proposed bill, now describes such a person as a defendant, basically synonymous with an accused, pitting that person against the state in an adversarial legal system that now has to be navigated after liberty has already been lost, but no charge has yet been laid for any offense. It might be considered that such a person should instead be referred to in the bill as a suspect, in keeping with the time-honored nomenclature that automatically carries with the above-mentioned safeguards. Circumscription of discretion, which is contained at paragraph 14 of the Council's submissions. Empirical research, if done, would have shown that the multiplicity of circumstances set out in Clause 7 that may justify the denial of bail, as well as numerous more that are not so set out, would be considered by a judge at some time or the other. Indeed, most of these are already set out in the current Bail Act, which, contrary to the impression being given, is quite comprehensive. In this regard, there is a potential positive effect, as setting out these factors might provide the framework for a sort of checklist that both the suspect and the prosecutor could benefit from. It is, however, in the nature of the exercise of judicial discretion that there is hardly any limits to the scenarios and circumstances that determine how discretion is exercised. To set them out in a statute that a judge must or may take into account in deciding whether or not to grant bail could even found a view that the express mention of those matters might mean that others not mentioned should not be considered. Paragraph 17, the codification that the bill seeks to make of the common practice of denial of bail to a suspect, ostensibly for the protection of the suspect, lends itself easily to obvious or cynical manipulation and abuse. There is no requirement for disclosing the grounds upon which the need for this protection is based. There is also a certain amount of unsoundness in the argument that the authorities are better able than the suspect is able to determine whether liberty or confinement is better for the protection of the suspect. Chairman, I want to move away from the written submissions and take us back to Section 14(1)(f) of the Charter, where it states in plain language that the arrest or the detention of a person is for the purpose of bringing him before the competent legal authority on reasonable suspicion of his having committed an offense, or where it is reasonably necessary to prevent his committing an offense. It is our understanding that the provisions of the intended bill is to introduce the regime of bail before charge. And in looking at this provision, Chairman, where it is stated and has been stated for many, many years, the circumstances under which there can be a deprivation of liberty, and in all democratic schemes of government and schemes of operation, there has to be those provisions, because there are persons who will have to be treated in a manner where they're deprived of their liberty, where they offend against the community. We know that the Charter is, however, clear in stating that the arrest or detention of a person is for the purpose, the aim of taking that individual before the competent legal authority. And it is our understanding that this provision, Chairman, does not contemplate the denial or the deprivation of liberty for the purpose of, and whether to start an investigation, whether to continue an investigation, whether to complete an investigation. Whereof we submit, Chairman, that the Charter as it currently stands does not contemplate bail before charge. And what we're doing is introducing new legal concepts. Nothing is wrong with introducing new legal concepts, provided it reaches and satisfies the rigors of our Charter of Fundamental Rights and Freedoms. Chairman, in keeping with the need for brevity and also to allow discussions, let me conclude by saying, notwithstanding our criticisms, it must be acknowledged that the bill desirably seeks to codify and consolidate most of the practices pertaining to bail, and commendably does not seek to deny the right to bail for any category of offenses. Thus, where bail is concerned, preserving the status quo of the general constitutional presumption of innocence. Those would be our submissions, Chairman. Of course, there can be further elaboration on Clause 5, which we find particularly troubling in that it really gives a police officer, admittedly of a certain rank, the right to restrict the movement of citizens and to impose conditions over citizens before a charge is laid. And it appears, Chairman, that that is punitive. We do not see any provisions in the law, for instance. Perhaps there may be regulations as to how the progression of investigations shall be tracked. So somebody is on bail, investigations continue, matters of disclosure to the person.
May I invite you to look at Clause 5, Subclause 6, and in particular B and C. I think it answers that question.
Let me take a look, Chair.
Yes. So the challenge, all right, let me
just
allow.
a moment.
Yes.
Clause 5.
Specifically in relation to what you've said.
And just give me back the intended.
Clause 5, Subclause 6 on page 5 of the bill. what is to be taken into account? The same things to be taken into account by the justice of the peace or the police at or above the rank of superintendent. Would you not say that is a way of tracking the investigation?
Chairman, it is not adequate. I have looked at that provision.
No, but you started by saying there is nothing in the bill.
Chairman,
yes.
Nothing in the bill up to a certain point, because my understanding, and you can elucidate, in relation to 5, subclause 5, there is an inter-party application. And
please look at 5(1)(b).
Yes?
Yes.
Yes.
This is the initial consideration.
The initial consideration.
Initial consideration.
The initial consideration,
yes.
Chairman. And where bail is not granted.
No, you're talking
to the
about.
Defendant,
no, let's take it in stages.
It appears, Chairman, that the defendant to whom bail is not granted has greater protection because that person is taken before the
court.
And that is one of the concerns that
but
the council has. In that, in
just
respect of bail, there is no charge. There is no charge. Yes, it is reasonable ground.
Let me permit
you must
the questions.
Yes.
I don't want it to become just a conversation between you and me, because I do have a number of questions, but let me just open for questions by members of the committee. I see Member Rodriguez Campbell hand raised.
Morning. Thank you, Madam Chair. And as usual, I always have to start by saying thank you to the persons who take the time to make these presentations, because this is what open parliaments are about. I have 3 quick things. Firstly, from your presentation, Mrs. Harrison Henry,
yes.
That's correct? You would not have been privy to our minutes of our meeting, and they were deferred. But last week, Member Jackson mentioned the issue of the defendant, the use of the term defendant that you have mentioned. And Madam Chair explained that that could be discussed in our clause by clause that we will be doing internally. So just to let you know, that was already flagged and it will be discussed at that time and a decision made. Now, you raised in your presentation the matter of JPs. And while I am in the Parliament, I'm not an attorney, and I'm also a JP. And so I have a very similar concern that you have about JPs having this power. But it is my understanding, and Madam Chair or Minister Chuck can correct me, JPs will be thoroughly trained. So it won't be business as usual. It's not with the knowledge that they now currently have. But the intention is for JPs to be prepared to do this. Is this something that you will be open to as accepting? So that's my first question. And secondly, you mentioned on page 3 of your presentation under the heading empirical research missing. You're not the first person I've heard make this comment, that where is the data to back it up? So for right now, it's an assertion or it's anecdotal.
Data is not put in law, please.
Sorry?
The data is not put in law.
No.
It informs the policy decision making.
Right. So she's speaking to the fact that the public does not know about the data. And I asked, know the data. Question I have for you. If that data, you became aware of it, would you be more comfortable? Because as the chairperson has indicated, the data has been used to make a policy decision. And it's from that policy decision comes the Bail Act, or the bail bill, as it is now. If the data is shown to back up, is it that yourself and your organization would be more comfortable with certain aspects of this bill?
May I, Chair? Thank you. I'm happy to know, member, that the use of the word defendant is being perhaps reviewed. May not be an appropriate expression, but it's being looked at more closely. And we're grateful to know that. In relation to the training of justices of the peace, we always believe that justices of the peace ought to receive greater training, as within our legal system, they are the first line of defense between the citizen and state authorities. So more training for them is absolutely critical. And we can see this also in regimes such as SOE and police operations generally. In relation to the third matter, data drives policy, as I understand it. We've heard the criticisms over the many years. Certainly we have asked to see the data, and to answer your question more specifically, I would have to see the data before I could answer your question. So our position...
No, sorry to cut you, but specifically, if the data provided the facts to justify the decisions that have been taken with the clauses in this bill, would you be open to it, to considering it and being more comfortable with it?
Member, one always has to keep an open mind and always has to look at data. I know from, whether from the council or from the bar, we've asked to see that data because our own experience as council, in the courts, we do not find any support for the allegation. Therefore, if the data is shared, it would throw perhaps light, give some background to this shifting scenario that we see in relation to some of the proposals. We have no issue with the actual codification, or, we speak of it in our submissions as a checklist for council in preparing for court. But specifically to answer your question, member, I would have to see the data before I could definitively answer you. But data and empirical investigation and material has to guide us, is how I would put it.
Member Bunting's hand.
Thank you, Madam Chair. And let me apologize that bandwidth limitations does not allow me to turn on my video. So let me just start by thanking the former public defender, the representative of the Independent Jamaica Council on Human Rights, for her presentation. I thoroughly enjoyed and appreciated it. And I found particularly powerful her distinction between assertions and empirical evidence. And I want to say evidence rather than data, because, there is this maxim about lies, damn lies, and statistics. And, if we can always choose data points that support our argument, but until an objective and competent analyst looks at the relevant universe of data and does some proper analysis of it, then we can't just use raw data to inform policy. So let me start out by saying that these assertions, which invariably come from the security forces, and we've seen so many of it recently. You know, we've seen when we were dealing with the Firearms Act, you know, this assertion that severe penalties will act as a deterrent to offenders, when the empirical studies all over the world have shown that it's the likelihood of detection in proper investigation, detection, convictions that really act as the deterrent, rather than these draconian penalties, which are rarely, if ever, applied because of you know, the breakdown in the rest of the law enforcement process. So we similarly now are where we hear that there's a lot of offenses committed by persons on bail. But I have never seen, I've heard this at least for the last 15 years, that I've been either shadow minister or minister, but I've never seen any comprehensive data set presented. You hear anecdotally of one here, one there. You hear of as many by persons who are serving sentences in prison and still giving instructions for, you know, hits on persons outside. But I have never seen a comprehensive analysis. And I suspect, I strongly suspect, and let me put it no higher than that, that it is these assertions that are informing policy, because I am sure if there were proper studies, they would be presented to the joint select committees and the various review committees of Parliament. I, for one, have asked for it on many occasions, and sometimes promised, but it has never actually been delivered. So I really appreciate the points that that you've made. I am very wary personally of this concept of preventative detention or detention to facilitate investigation. I think it's all very much, you know, on a slippery slope, particularly as the time frame to allow this. I mean, I think in 2010, when we were looking at those original bills that restricted bail, you know, we were talking then about detention without charge for 48 or 72 hours. But with the passage of time and the use of states of emergency as a routine tool of policing, we now see these detention to allow investigation going for well over a year. And I think that's just absolutely unacceptable. And we keep pushing these on the basis of assertions. The government will seem to be doing something. I think that's the primary purpose of much of these initiatives, so that the government seems to be doing something, when the real work, and I ask you to, as someone very experienced in the judicial process and the law enforcement system, to comment on this. Is it not that the real work that we need is, on the one hand, on crime prevention, the interventions all along the system that will, you know, cut off the supply of these potential criminals on the one hand, and on the crime control side, to build the capacity to do proper intelligence collection, investigations, and to put strong cases together which result in convictions, rather than all these other things which are, you know, tangential, in my opinion. But I would love to hear your views on it, Mrs. Harrison Henry.
May I, Chair?
Yes, please.
The matter of the constitutionality of the proposed bill is the primary concern of the council, as the chairman well knows, as to whether or not the charter itself contemplates this regime that we seek to introduce. As to crime-fighting measures, I do not wish to engage member into that kind of conversation. What I can say is that certainly my experience under SOE is that I saw detentions, thousands of detentions, I would say, of primarily young men being taken into custody to be, I'm using my word now,
Pardon me, can you pull the mic up a little bit more? Thank you.
Young men, using my word, to be checked out, but the word used by police officers was processed. So in other words, though the regulations would have had the legal threshold to be met, such as the intended bill has, the reasonable ground, because it is a reasonableness that is what protects human rights and civil liberties, the reasonableness which has subjective and objective parts. But what it leaves itself open to potential abuse, where persons are taken into custody, put on bail, as we saw during the states of emergency, that you are held in custody pending somebody processing you, which really means taking your fingerprint and determining whether or not you're wanted by the police. And I do not think, Chairman, based on certainly what I saw and the impact on young minds, that we should even contemplate that. I believe in thorough investigation, and we have seen where, particularly in complex matters, investigations can take place over years to come to fruition for successful prosecution, because the council holds the view that communities are to be protected. It is not only defendants' rights that need protection, but communities need to be protected from wrongdoers.
Thank you. Thank you. I see Member Jackson. I'll come back to my set of questions. Member Jackson?
Yes, thank you. Thank you, Chairman. Chairman, permit me to also extend my thanks and appreciation to Ms. Harrison Henry for taking, she and her organization, Independent Jamaican Council for Human Rights, for taking the time and the effort to put together the presentation and now to appear before the committee and by extension to the rest of the country to share your perspective. A couple of the points I wanted to touch on, Member Bunting had made some mention of them, but my particular one is, Henry, the whole question of the JP and the police officer, and particularly the police officer, be now elevated to the level of a judge to determine, to deny bail. Because the essence of it, is that when somebody is detained, is held, the question is whether or not you're going to hold them and deny them of their freedom. That is the essence of it. I repeat what I said in previous sitting. Every person that is held is presumed innocent, which could be you, Ms. Henry, could be me, could be the chairman of the committee, is presumed to be innocent. Now, if the police have compelling information and evidence that I should not have my freedom, then you need to take the steps to protect the society from these persons. And of course, because the arresting officer is not judge and jury, it has to go to another level, to the judiciary, to make that judgment between the suspect and the arresting person, the police and the other. I have a little uneasiness. Though the bill make provision for a police officer at the rank of superintendent and above, the constable or the corporal, whenever he acts, he's not acting on behalf of himself. He's acting on behalf of the entire JCF. So when you move it to the superintendent, he's acting on behalf of the same JCF. But as I understand it, and I stand to be corrected, when you go to the judiciary, you're moving out of the JCF altogether. A different organization, a different entity that is exercising the judgment, or whatever wrong. So I must share with you that I have I'm going to put it this way, I'm not comforted in the fact that a JP or a superintendent is going to exercise the judgment as to my being denied bail. I rather to go to a judge. If you charge me or whoever else, then all the provisions of bail, you can access the judiciary system to get bail. But this thing about allowing the superintendent to basically exercise within that 48 hours and next 48 hours perhaps is not a source of comfort. And lastly, I want to share Ms. Harris. What makes me so uneasy with this provision of pre-charge detention is the fact that I saw what happened with the same thousands of persons who were detained on the state of emergency, which is just a different language used for the same thing, because everybody that were detained under the state of emergency were not charged. Or at least, well, all of them initially were not charged. But they were detained and denied of their freedom. This provision of pre-charge detention, and by extension, pre-charge bail, is just another version of a state of emergency where the authorities, the police, can pick up anybody and detain them without charging them for extended periods of time. And why I'm worried about it, during the state of emergency, I remember in Montego in St. James, I had the experience of interviewing a number of persons who were detained and subsequently released after many, many weeks of detention in a police cell. It's not a hotel room. And to be told of the inhumane conditions. Some of them I saw myself when I visited some of the cell blocks in Montego Bay that they were held. It's not a place where the chairman or you or myself want to be spending some time until some investigations are completed. To be denied of our freedom in those circumstances. So the point I'm trying to make is that to deny someone of their freedom ought not to be taken lightly. And when the state begins to exercise that discretion of denying somebody of their freedom and subjecting them to those really inhumane conditions, it is not something that brings much comfort to me. So I do share your concern, Ms. Henry, about these extended and likely extending periods of detention until the officers the police become satisfied that no, you can go home now in order to charge you. Those are my comments.
Thank you, Member Jackson. Thank you. All right. Let me just say that it is of critical importance that comments refer to what is contained in the bill. I find it a little difficult when statements are made without reference to what is provided for in the bill. firstly. Secondly, no single piece of legislation can address all of the issues. Admittedly, there are concerns about how laws are implemented and how they are enforced. Those are a different set of concerns from what the law provides for. So it's interesting that Madam Harrison Henry, as about to say Madam Public Defender, like you, our starting point in the analysis is with the Constitution. And I find that almost everyone has referred to Section 14.1. Let us look at what it says and what the Constitution says. You've said something about not reading down rights. Very profound statement. So the Constitution provides that a person can be deprived of his liberty for the purpose of bringing him before the competent legal authority on reasonable suspicion of his having committed an offense. You can't hold unconstitutional what the Constitution provides for. So we know that persons can constitutionally be deprived of his liberty where he is reasonably suspected of having committed an offense. And you deprive him of his liberty in order to bring him before the competent legal authority. It doesn't say just a court. It's not just a court which the Constitution provides for to be the competent legal authority. And that is borne out in another part of the Constitution which speaks to the person being deprived of liberty is to be taken before the competent legal authority or the court. All right?
Chair, if I might,
yes.
The clerk is going to give you a document that I'm asking you to look at and bear in mind in terms of my time. Right. But I think the point I was making, Chair, in relation to F, 14.1F, is I emphasize the use of the word purpose. Purpose. In other words, the aim, the determination has a purpose. It is not for the continuation or the commencement of an investigation or the completion of an investigation. So I emphasize purpose because, Chair, as we said, the primary purpose of governance is to keep a society safe.
I understand the point. I understand the point you're making, but in making the point, when we're questioning whether the Constitution permits something, it's also important to look at what the Constitution says and look at also how it is interpreted and the guidance of the court in terms of the different rules of interpretation. So we can accept that persons suspected, reasonably suspected of committing an offense may constitutionally be deprived of his liberty. There's no dispute about that.
There could never be a dispute about that,
absolutely.
Chairman.
Thank you. And we can agree that the Constitution provides for such a person to be brought before a competent legal authority. That itself is set out at 14.1, and it is also set out at 14.3, when it speaks to any person who is arrested or detained shall be entitled to be tried within a reasonable time and shall be brought as soon as is reasonably practicable before an officer authorized by law or a court. So that the Constitution itself tells you that it is not just a court that you bring the person before. So the bail bill, in its definition of deciding officials on page 2, clause 2, identifies the court, the judge, the justice of the peace, or the constable, and constable is used as any rank of the JCF, not just the rank of constable, who is the competent legal authority on any matter of the grant of bail or any question relating to bail pursuant to this act or any other act. So that scheme is in keeping with what the Constitution permits. Now, the question about the discomfort of a police or a JP granting bail, it happens today because bail is granted out of court. Long before the person is taken to court, bail is considered at the station. And station bail is granted, and it is part of practice, procedure, and law here currently. Station bail is granted.
Chairman, I think we understand that.
Right, but I don't know that everybody understands
Station bail is something that we're accustomed to.
Exactly.
And there are times, Chairman, on a weekend where you might have to find a justice of the peace.
Indeed.
To consider bail.
Indeed.
But I think that, notwithstanding that, we're looking at a completely different scenario as is contained in the proposed bill.
Not entirely, Mrs. Harrison. Hear me out.
It is completely different. Chairman, it's a matter of interpretation, you know, and it's a matter of perspective as to whether or not we can have bail before a charge. Because when we go to the JP over the weekend for bail, it is not bail before a charge, it's the standard.
Remember you have indicated about not reading down rights. Brilliantly so. And also, so let me ask now. Right. So
important.
If you take it
the
literally.
Charter gave us some rights, Chairman.
Walk with me.
That are the Parliament.
Walk with me.
The Parliament gave us rights, gave the people of Jamaica
Walk
rights.
with me, Mrs. Harrison Henry.
That we need at all times
I'm
to
following
preserve.
your logic.
But Chairman, did you get my note?
I got your note.
And,
but before you have to
last time, I
yes.
have.
But before you have
limited
to run, I just
time.
need your assistance on some matters, because so that so we hear of the discomfort with the police or the JP being granted the authority to grant bail, but we know that it exists now. It is part of the law and it is permissible constitutionally. If they are designated the competent legal authority on the matter, it's constitutionally permissible and it exists now. All right. So, hear me now. Not everyone who is suspected of committing an offense is going to be detained or charged. Detained before the charge. The detention can actually take place when they are arrested. So they are arrested, you go out with a warrant and you charge the person. But to the extent that the Constitution says that as an exception to the right to liberty, a person may be deprived of that right for the purpose of bringing him before the competent legal authority on reasonable suspicion of his having committed an offense. The question arises, if you properly detain someone because you reasonably suspect the person of having committed an offense, it's not the start of the investigation, because you would have had something in order to so reasonably suspect the person of having committed an offense. And that can be tested. What then do you do with the person? Because you do not move from detention and arrest to trial within a reasonable time. What then do you do with the person as you take the various steps along the spectrum? What do you do with them? Have them languish in custody? What the law provides for. It sets a minimum time frame for persons who are taken into custody on reasonable suspicion of they having committed an offense for the question of bail to be considered. And it is standard. It says that bail can be granted by the justice of the peace or the police even before you take the person to court, within a time frame. Then it says if you deny them, you take them before the court. And I'm trying to wonder wherein lies the harm in that. Because if the option is between depriving the person entirely of their liberty, as is permissible, and releasing them on condition as the Constitution allows, which provides a greater harm, or which provides a greater justice to the person, which provides a greater protection to the person's liberty. I'm still trying to understand which law is being read and understood. Because even without the new provision, today in the law, a person can be denied, the person is taken in, the question of bail is considered out of court, except for those which the law specify must only be considered by a court. If it is proper, bail is granted. If it is not denied, they are brought before the court. Same thing that exists now, in principle, protecting the rights that are guaranteed. We've had too many cases of persons being taken into custody where no charge is preferred within a reasonable time. They're languishing in custody. And applications are brought. Habeas corpus, applications are brought. And what is the harm where the law says that having taken the person in custody on reasonable suspicion of that person having committed an offense, you must consider whether bail should be granted until you take all of the many steps that are involved to get to trial in a reasonable time. When you talk about not reading down rights, this is exactly what has happened. Using, as the Privy Council has said and our courts, that when you are interpreting rights provision, you give them a generous and purposive interpretation, and in particular, the provisions that enshrine fundamental rights and freedom should receive a generous, not a literalist interpretation. And the same guidance says rejection of a narrow or legalistic interpretation cannot mean that other sections of a constitution can be construed as creating rights which they do not contain. Matadine and Pontu. So that if it is that when we look on purposively, that a person who is taken into custody, deprived of his liberty on reasonable suspicion of his having committed an offense, that person ultimately must be charged and tried for the offense. But before you get to trial, there are a number of steps that must be taken. And we're saying, don't keep that person in custody unless it is critical, having regard to the aims of justice. And where appropriate, such a person is to be released on bail on condition. And it is the court where such a person is to be held in custody, who will determine for how long and on what conditions. I've been scratching my head to find out which law is being discussed. Is it because the suspicions are so great that we really cannot read the provisions of the law and make sense of them? Now, I know we disagree, and I know there are lots of issues. But again, I say it is always unhelpful when we speak about the issues, because a lot of the constitutional points being raised, they are not all accurate. Not all accurate insofar as what is actually provided in the Constitution or how the courts say that we should interpret them. Not by you in particular, or the deep dive is not done. So we're talking about, so even the question of whether the police or the JP can grant bail. Discomfort with their doing so does not equate to it being permissible legally and constitutionally. So the point about wary of preventive detention, Member Bunting has raised. Whether you're wary or you're not wary, soon come to you. The Constitution itself allows it. The Constitution explicitly allows it. That a person may be deprived of their liberty for the purpose of bringing them before the competent legal authority, for the purpose of preventing that person from committing an offense. So my discomfort or anybody's discomfort is neither here nor there. But I mean, it's when the Constitution permits it, the Constitution permits it. Our experience may say that let us look at how now it is dealt with. So we have to draw the distinction between what is permissible explicitly or impliedly, constitutionally. And everybody's talking about detention. This is a bail act. It is talking about the grant of bail. Now we know the flip side.
Before charge.
Mrs. Harrison Henry,
Forgive
your
me, Chair.
point, I
Forgive me.
understand. No. But your point is that it's not, you express your discomfort, but your point is that the jurisdiction should be given exclusively to the court. That is what I understand from your submission, in spite of your discomfort.
Chairman,
Yes.
we regard it as an erosion.
As a?
Erosion of the...
Erosion on the protection of the liberty of the subject?
An erosion. In fact, Chair, it is expressed, I think, very clearly in our submissions, you know, when we speak about that the regime of bail in which the role of the judiciary arises after that of the police and justices of the peace. What we see, Chairman,
that's what exists now. But that's what exists now.
Is that no, we're looking at the totality of the provision.
But that is what exists now.
We're looking at the totality
and
of
it
the
is done to
provisions
benefit, not to deprive.
that there is an erosion of the role of the judiciary. Those are our...
But
we understand that you would have an
different
alternative position.
But I still
those are
would like an
our
opportunity to engage, because currently on the grant of bail, even in an application for habeas corpus, you don't get to the court at a first juncture. You go through the competent legal authority of the police and whomever is detaining the person. So I'm kind of, coming to you, Member Sinclair, I'm kind of genuinely trying to understand the point, because the court is not the first port of call. And currently, the court is not the first port of call in the grant or denial of bail. And so, I can't see how, I'm genuinely trying to understand how, in the current scheme, where it is not the court that would exercise the power of arrest or detention, but that it must get to court as a next step, it is an erosion of the judicial powers. I don't understand it.
Chairman, I think you have, for me and for the council, you have to look at the totality of the scheme created by the intended bill. And it is in that context where we're introducing a new situation of bail before charge, where under the provisions, the clauses of the intended bill, the police are allowed under Clause 5 to grant bail prior to charge. And I think
but
when
where,
you respond,
but where the police
Chairman,
reasonably suspects that the person has committed an offense.
Chairman, it's to offer bail to someone before charge goes against the fundamental grains of human rights norms. what you do is you impose restrictions on individuals, whether by the police or under Clause 5, where the police does not grant bail, you go to the court for them to consider bail. What we're doing is imposing restrictions. We're putting people in a situation, I'm going to use the word limbo. We don't know when a charge will come. We don't know if a charge will come. But what I do know is that, hey, I'm on bail. I'm on bail. What am I suspected for? We expect that the police officers and the process will eventually divulge that to you. You referred me, Chairman, to a particular provision. And we see the inter-party application where where parties, and I imagine that at this stage there's some disclosure between the the police and the person representing this defendant who is really a suspect. And I
have no dispute with the person being a suspect, just to let you know.
Very well.
Yes.
I'm thankful for that. Chairman, that small measure. I'm indeed
the
thankful.
CPC, in fairness to her, will give you an explanation. So there is no dispute. There is much clarity as to what the person is at the various stage.
Very well.
Because the law is very clear on that.
But Chairman,
yes.
we introduce a burden on a citizen to be bailed. You put that individual in confrontation with a system of an adversarial system of justice, he having not been charged. You are saying to him, you may have to answer, but right now we're not quite sure, but we will offer you bail.
Madam,
Chairman, something has
Mrs.
to be
Harrison
wrong.
Henry, I think
it's put in.
think
Chairman, something has to be.
Let me ask
profoundly wrong within our understanding of our legal system.
Mrs. Harrison Henry.
Yes.
It is not any person. It is a person who is reasonably suspected of having committed the offense.
Chairman,
so the impression, just a minute, just allow me. The impression is being given that it is any person who is being plucked out of the society who is now going to be put on bail. It is the person whom the Constitution says it is quite permissible to deprive him of his liberty on reasonable grounds in accordance with fair procedures for the purpose of bringing him before the competent legal authority on reasonable suspicion of his having committed an offense.
Chairman.
So it is a particular category of person. It is not just anyone. And as you rightly said, the presence of reasonableness is what distinguishes it from being arbitrary.
But Chairman, I certainly would not want to give the impression that it is anyone, any John Brown outside, but it's in the context of the conversation.
No, but you see, it matters. But it matters.
And Chairman, I'm in full agreement with you on that. Full agreement. So let us be very clear. It is those persons where reasonable ground exists who the provision
Look at what the law provides
applicable.
for. Mrs.
No,
Harrison
Chairman,
Henry.
what the bill provides for.
No, this one, yes.
The
Here
bill,
is
not
what
the law yet.
the proposed law. But here is what it says. Here is what it says. But here is what it says.
Yes.
And again, this is
Where
why.
are you, Chairman?
Clause 5. Clause 5 says.
Reasonable ground.
Where,
Yes.
on reasonable grounds,
Yes.
that the defendant, let's substitute the suspect, has committed an offense. Not just any offense either.
But
Serious
within the
offenses.
schedule.
Right. So again, it's serious offenses, punishable with imprisonment.
Yes.
Because it means that on conviction, you're going to be deprived of your liberty. The defendant is arrested, but is not yet charged. So it's not that the defendant is just arrested like that, you know. The defendant is arrested because reasonable grounds are present that he has committed serious offenses punishable with imprisonment. But the police now needs, the charge has not been preferred because the police needs more time. You know, just this morning, I was informed of a particular matter where someone was taken into custody for ammunition was found in the person's possession, and an explanation was given. And the police are saying that we're wondering whether they should just hold off preferring the charge in order to inquire whether the explanation given by the person is correct. I mean, is true and provable. And that would determine whether they proceed to charge or not. But in order to make that determination, they would have to contact external parties because it involves, the person is from another jurisdiction. There are many legitimate circumstances in which the police may require some time to prefer the charge, where the suspicion that the person has committed an offense is reasonable and proper. I think we are locking ourselves into only some examples. It appears so. But let me go back to this. So the person, not just any member of the public, is taken in. It's a person who is reasonably suspected of having committed an offense. That is the reason for his detention. That is it. Reasonable grounds. Well, but the law uses it interchangeably. No. The law uses it interchangeably. But even if we substitute exactly what it says, it amounts to the same thing. Yes.
It's my own view.
Yes.
As I haven't looked at it for a little while.
Yes.
I think reasonable ground
is even a higher threshold.
Higher threshold than reasonable suspicion. Because it is.
Exactly.
So.
Exactly.
That is what I'm saying. It's two different things, Chair.
But
we were looking at
Mrs. Harrison Henry,
together.
but you have touched on something because it was a deliberate decision of our putting it that way.
And as I said,
So
we can't read rights down.
Remember your
reasonable, yes, Chair.
Right.
But reasonable ground.
That's even a higher threshold to meet.
Threshold
yes.
than reasonable suspicion.
Right. And whose benefit would that inure to? The suspects.
Chairman,
the suspects.
Ultimately,
the suspects.
It endures to the society's benefit.
And the suspects.
And the victim.
Yes, right.
Because the victim,
all right,
who we haven't spoken about yet, where there's someone on bail without having been charged, the victim is unaware of the outcome of a complaint that he or she has made. So it's not just a defendant
all right, so,
who is impacted.
All right, we're not saying two different things.
It's also the victim and the community at large.
So we have, the Constitution sets the limit, and we have put it where we have put it. So the point I'm making is that it is not just any person, and it is not whimsically. It is not just a man says so. There has to be proper basis that meets the legal and constitutional threshold. Hold on.
But
what does it say? Let's look at what it says, man. It says that the question of bail shall, within the period of time, be considered by the JP or the constable. Now, as a safeguard, it is not the constable who has arrested the person or who is involved in the investigation, because it says that those deciding officials must consider specific matters. And those specific matters are set out at 6. A, B, C, D, E, or G. A says, you have to consider the grounds on which it is alleged that there is reason to believe that the defendant has committed the offense. So a man is not justifying it to himself. He's not his own arbiter, the one who has the suspicion or the grounds. He has to demonstrate it to someone else. Then you're looking at the stage at which the investigation has reached and the manner in which it has been conducted, and whether further time would enable a charge to be preferred. It also says, look at the conduct of the defendant. Look at the reasons given as to why the defendant has not yet been charged. And it is been said that in those circumstances, prejudice is being caused to someone who is taken into custody, where the Constitution provides that such a person can be taken into custody. Every single safeguard having regard to concerns raised, how is the investigation being conducted? Because that was one of the major issues in the information we analyzed coming out of even the SOEs. Even points raised by you in your role as public defender. The importance of having a place where an arresting officer or an investigating officer can demonstrate how he has been investigating, what stage it has reached, the manner in which he has conducted it. Because it is time-bound. This is not a situation where there isn't a boundedness, for want of a better word. And I am wondering, how is it more detrimental? It allows for matters to be dealt with case by case on their own merits. So when Member Bunting spoke of his wariness of preventive detention, that wariness does not impact the constitutionality of it, because the Constitution provides it. Crime prevention, he says, is the real problem. But crime prevention is one set where the crime has been committed, you actually have to deal with it. And he spoke to putting strong cases together for conviction. What do you think this is allowing?
No, I didn't say crime prevention is a real problem.
You said crime prevention to cut off supply. Two limbs you spoke to.
Yes, that's the solution.
Right.
That's the problem.
Yes.
Not the problem.
Real work, you say, is on crime prevention to cut off supplies, or crime control to build intelligence and put strong cases together for conviction. Did I mishear you?
I'm not sure, but when you spoke to me, quoting me on wariness, I want to make it clear it was W-A-R-I, not W-E-A-R-I.
No,
wariness in terms of caution about possible dangers or problems.
Right. Well, I
not
understood.
That I was tired of it.
Got you. So my point in response is that regardless of how we feel about a course of action, in the context of this deliberation, the question is, does the Constitution allow it? And the Constitution does allow preventive detention. It does allow it where it is reasonably necessary to prevent the person from committing an offense. And what the Constitution provides for cannot be held to be unconstitutional. Because it is the own Constitution that you're adjudging the standard against. So just to say, when I hear that we're not going clause by clause, but we're speaking generally, and if we are agreed in terms of what the Constitution provides and what is in our current law, then let us look at what the bill is providing for and do the analysis accordingly. So it's not anyone. And this is a situation which is saying, under no circumstance should someone be held in custody where the person can properly be put on bail until you are able to try him within a reasonable time. Because, you know, to use an analogy, the judge's rule, when you're questioning someone, as you know, Mrs. Harrison Henry, provides for a greater latitude. The minute you make a certain determination, it operates almost like a crystallization. And then time, strictness run after that. The latitude constricts. And the same happens where, having charged someone, because you're already determined now that the person is formally accused of it, everything runs strictly after that. Greater latitude exists up to that point, before the charge. The law, in its wisdom, recognizes that. And what this is saying, that having arrested or detained the person on reasonable suspicion that the person has committed serious offenses punishable with imprisonment, you're not going to get to the trial within reasonable time, which is the ultimate goal, without taking many steps in between. Consider what you do with his liberty. That is really what we're getting to. And it is in response to so many concerns raised in the society. Don't lock up everybody, even where you suspect that they have committed offense, because at the end of the day, they are supposed to be tried. We know the difficulties in investigating certain kinds of offense in certain types of communities against certain types of alleged offenders. And I keep wondering which law is being spoken about. Have we looked at what we're seeking to provide for as currently exists? In any matter where a proper decision is taken to deny bail, that person will remain in custody. Lawfully and constitutionally so. Even after appeal. And I'm wondering which law we're talking about here. Because everybody has come with a vendetta and is not really looking, not really looking on what we're seeking to provide for. So if you say, boy, you know, we hear about the hundreds and thousands of people locked up. We don't even make the distinction or ask for the distinction. Were they preventatively detained as the Constitution say they can? Because the only question that arises thereafter is for how long, and all of the other matters that must kick in once an arrest or detention takes place. I'm just wondering. And if the concern is that, go after specific people, no other provision so far allows for that than this. Because each case and each defendant is going to be considered on the merits. So if we agree that you read the provision purposively, the real question is, what do you do with someone who has been arrested or detained on suspicion that the person has committed an offense? What do you do with them until you come to try them? Because the initial act of the arrest or detention is a proper one according to the Constitution for the reasons set out. And what you must do with them is to take them before the competent authority. It doesn't say a court. So the separation of powers is not breached because some powers are shared. There are some powers that are exclusive to each branch. The power to legislate is exclusive to the legislative branch. The power to adjudicate is not necessarily exclusive either. But the power to hand down a sentence is exclusively the domain of the court. The power to deprive a person of his liberty is not the exclusive domain of the court. But it is not the end of the matter. You spoke, Mrs. Harrison Henry, about the importance of protecting the community also. And I invite you to look at what is provided for at Clause 7 3I2 on page 10 of the bill.
Chairman,
Yeah.
my comment in respect of the community is a general comment that we need to take into account.
And one with which we agree.
General comment,
Yes.
and as I indicated before I started, that I indicated the areas that I wanted to concentrate on, but I'm very mindful of the importance of the community and the protection of victims. So it's not only suspects and defendants.
And we have
that
provided
the
for it.
council has
Yes.
interest in.
Part of the empirical data that we have assessed, because these concerns have been raised repeatedly. And that is why it is one of the factors to be taken into account. And it works favorably. It works on both sides of the equation. So the empirical research is presented in many features of the bill, particularly the matters to be considered in deciding bail, and in particular, before the charge is preferred, in respect of the investigation, the grounds on which it is alleged, the manner in which it has been conducted. Those are issues that have come up repeatedly in concerns raised about persons taken into custody who are suspected of having committed an offense. The issue about how a community is impacted, those are issues that have been raised also, and they show up again in the provision which says that is a matter specifically that you take into account as a guide. So data is not set out in the way that some people think it is, but it informs provisions. And I think that is what has happened. So I say the separation of powers principle. The Constitution does not say it's only the court that has jurisdiction for these matters. And we have established who the competent legal authority is by virtue of the definition of the deciding official. We agree with you about the not reading down the rights, and that's why the right to bail is read purposively. What do you do with someone who has been taken into custody on reasonable suspicion of his having committed an offense until you get to trial within a reasonable time?
Not following that, is it not that we charge the person?
But yes, but remember it says it's
is
charged.
It not that we charge them and get them in the system and
absolutely
go through?
But before that, don't lock them down in custody unnecessarily.
And so
all of the many steps must be taken.
All the many steps
must be taken
to protect the right to trial within a reasonable time. The fundamental objection, Chairman, is the matter of bail before charge. We have identified, and I appreciate, Chairman, that in your putting forward this bill, that we will have these disagreements as to whether or not it is constitutionally sound within the current framework. And as I had indicated to you, Madam Chair, I'd sent a note to you that I do have an appointment. And as a retired person, Chairman, I'm very, very busy.
You know, Mrs. Harrison Henry, you come to the table with a lot of experience, and one of the issues you raised about the data. And I say to you that the data informs the provisions of the bill in various ways and the policy behind it. And I have identified the concerns about how an investigation is done, hence the requirement in law for the officer who has arrested or detained the person to demonstrate to someone else, not himself, how that is happening, issues around concerns with the community. But just to say that the first fundamentally guaranteed right that is engaged on arrest or detention is a right to liberty. That is the first one. It is not the only one, but that is the starting one. And what the provision does, yes, it's the first one.
But Chair, you know,
Not the only one.
No, not the only one.
Yes.
But Chair, you know, sometimes we define that liberty in a very narrow way.
But how can it
You
be
know,
more?
and it is
No, Mrs. Harrison Henry.
The liberty consists of so much more than the mere
That's why
right
we say
to go
starting
about your
point.
business.
But that's why
You
we say
know?
starting point. Starting
Can
point.
only be a starting point, because it is such an all-embracing and all-encompassing right that it is not
No
merely the
disagreement there.
restriction.
No disagreement there.
Denies you the right to go to church, the right to go to a party down the road, the right to sit in your
But
yard
can you
and do
imagine how
nothing.
much more deprived the suspect would be when he's locked down in custody? He can't go anywhere.
You see, Chair, I think
He can't go anywhere.
I think the dividing line here is where there are reasonable grounds, not reasonable suspicion, reasonable grounds that someone has committed an offense. It is an inescapable duty
To charge.
of the state.
To charge.
No, Chair, no,
To do
not
what?
to charge. To put your house in order by virtue of the material you have gathered, and to lay a charge. There are certain circumstances, Madam Chair, as you well know, in which the situation is so great that you have to detain the person. You have to take the person out of the community, even though at that moment you are not able to put a charge. But the crime is of such a magnitude, the potential impact is of such a magnitude that you have to remove the person. It is the creation of a system.
You spoke about restrictions.
If you just allow me. Therefore, the detention, where the circumstances are so horrific, and we have so many of them in Jamaica that I don't need to identify. It may require detention and a quick collection of statements to be able to lay a charge. You and I, Chairman, know that even when a defendant goes before the court, chances are the case is not yet ready, and the prosecuting authority is given more time to collect statements. But the defendant stands accused. He knows what he's standing there for. He's not on any bail before charge. We are saying that that is a fundamental problem in respect of human rights norms. You know, and
I see
Chair, with
Member
that,
Sinclair's
you know, I'm going to
hand
have
has
to
been
ask
raised.
you to allow me.
Yes. Yes.
I
I understand.
I thank
I understand.
the administrative assistant for calling me yesterday, though it was late, and I was not able to change my appointment and just trust that they will take me,
So
notwithstanding that I'm late.
So just to ensure that the denial of bail has to do with cynical manipulation, practice to deny, essentially.
Also, Chairman, in that part, we would also want us to think about bias, you know.
But
bias.
the law,
but Chairman,
but that's why it's not the same officer who is arresting that is going to grant the bail.
but we understand that, Madam Chair. That does not prevent,
Station bail
it does
exists.
not remove bias.
Not even from the
Whether
judge.
real or perceived, it doesn't remove it.
It's a human element, but thankfully the law sets out good guidance in how to deal with it, even where it exists in a judge, ultimately by recusal or other things. It's a human element. But just
Chair,
remember,
that is something.
station bail exists now.
Station bail exists.
And the Constitution doesn't say the court is the only person or entity or authority.
Chairman,
that can grant bail.
We do not have those basic disagreements. Station bail has existed. We know that habeas corpus is alive and well,
Yes.
even under SOE
Exactly.
and even under this regime.
As in this bail bill.
Even
Yes.
under this
Yes.
intention.
The bill. But I'm saying, but somebody else came and said otherwise. Believe it or not. Somebody came and said the bail bill has done away with habeas corpus.
No, Chair. And
I'm just telling you, the submissions are before us.
And as we know as attorneys, one does not have to wait to apply for habeas corpus in appropriate circumstances. You know, Chairman, I really
I don't wish to
go.
detain you beyond.
Pardon?
I don't wish to detain you. I do not think that there is much
this
disagreement.
This is called pre-appointment detention.
Sorry?
Pre-appointment detention.
What he said?
This is Harrison Henry in pre-appointment detention.
But Chair, it's really, and members of the committee, it's really an appointment that I have to keep. So I really do thank you.
Let me just hear Member Sinclair, whose hand has been up for a long time. Member Sinclair?
Thank you. Thank you.
And I don't wish to pre-appointment detain Mrs. Harrison Henry. So, yes.
You know, I was listening to the discussion and the various explanations that you gave. And I think you did very well, Madam Chair, in explaining what is contained and to address the concerns that has been raised in respect to 5, the clause 5 as it is written. And what I like about clause 5, but I probably should start elsewhere because I pulled on all the various legislation, the Constabulary Force Act, Section 15, that once a person is arrested, person can be taken for a justice of the peace forthwith to determine the issue of bail. Right? So, as you said rightly, the issue of bail is considered, first of all, by the police and by justice of the peace. I don't think you have done any changes in this regard, save and except now that you have specified that where the person is detained, it is a superintendent or constable at or above the rank of superintendent. But then when I look at B, there are some objective things that the superintendent will have to look at, which is, I believe, something very, very good and commendable. But I wanted to find out from Ms. Harrison Henry.
She's going to be pre-appointment detained.
Well, probably
tomorrow.
you can also address it. You can also address it, Madam Chair. But under the Judicature Parish Courts Act, where it provides, and we refer to it as attorneys making applications under Section 286, where a person is detained. So I will just read it. When any person is confined in any prison or place within his jurisdiction, that is the parish court, parish judge's jurisdiction, it shall be lawful for the magistrate to issue an order under his hand and under the seal of the court for bringing up before the court such person for the purpose of making inquiries into the circumstances and reasons for the detention of such person and of making such orders in the circumstances as he thinks fit. Now, the person is not charged. But 286 has 2 paragraphs, one that speaks to charge and one where the person is just detained and is in confinement. Now, what we have seen in practice as attorneys is that a person is in custody, would have gone beyond the 24-hour period of being in custody, and an approach is made to the parish court judge. The judge will invariably summon the police to find out what is the situation with this person. He's not charged. What is the situation? The police may indicate, well, you know, Judge, we're doing certain investigations which we expect to have wrapped up in, say, 6 days, 5 days, as the case may be, and it provides a good argument to the judge in that regard. Can't the judge generally reminds the person until, say, the 7th day, and it is either his charge or release. And at the 7th day, doesn't speak about bail. I've never seen a situation where bail is given in those circumstances to the person. So his liberty is restricted. Now, what I'm getting from this particular bill is that in those circumstances, a judge may look and consider all the circumstances and may say, all right, instead of you remaining in the confines of the police at the lockup in a cell, you can be placed on bail with these conditions. Possibly, you will report to the police so that we ensure that your presence, you are still in the area and under the control of the police. You can report to the police station at any time between the hours of so and so and so on Monday, Wednesday, Friday, as the case may be. Curfew hours at your home, right? So you're in the comfort of your home for the period that the police has asked. And if the police comes up with a charge, and they come up with a charge and they charge you at that time. So I thought this, what you have provided for in 5 is a better situation than what even presently exists. And I've been listening to all the arguments that have come up before from the various presenters. And the same challenge that you have, Madam Chair, I am having that same challenge in trying to understand what is the concern that exists. A judge right now does not, I would submit, at least in practice, is not able to give you bail before a charge. A police officer is not able to give you bail and allow you to go about your business with restrictions, yes, under the existing situation of the Bail Act. So I was just trying to find out in a scenario where the judge would generally say, and in practice does say, brought under 286, police provides good argument, and the judge says, well, I will remand you until 2 weeks' time because I can't do anything else.
I wish to cut you, Member Sinclair. We have another presentation to receive from Mr. Jordan A.J. Jarrett, who is here. Madam Harrison Henry, you wish to respond quickly to?
Certainly. I find my learned friends' observations to be interesting. And I agree with him that the judge, whether the parish court judge or the judge of the Supreme Court or any higher level, cannot give bail because there is no charge. And we know that during the process of habeas corpus, what the court does is offer some supervisory role over the investigations or over the conduct of the police officer until there's a determination as to whether or not the court will make the order for the immediate release or make another order allowing the police officer more time in which to put his act together and to have the relevant material presented to the court. But my learned friend from Montego Bay said, you know, in a situation like that, well, rather than spending the detention time in the lockups, a court could put you on pre-charge bail, and which would one prefer? And his position is that he would prefer pre-charge bail. In the habeas corpus application, which for those of us who may not be so familiar with it, is an application where it is heard over a short period of time in the protection of the liberty of the citizen. And therefore, I would say in a few days, the court makes a determination as to whether this detainee is to be released or to be kept. And where the person is to be kept, the court would normally make an order that the police has to charge the person within a certain period of time.
It's also provided here, by the way.
Which,
if the charge is not done within a specified time, the person has to be released unconditionally.
Yes, but Madam Chair, just responding to my friend, if some persons may well say the ultimate determination or the speedier determination is to go the route by habeas corpus, because at that time the police officers are forced, if they have a real interest in that detainee, they are forced to bring the relevant material to the court, because the court's duty is to examine the circumstances under which the person has come to be in detention and to determine, and I don't remember all the words or the terminology within Section 267 of the Judicature Parish Court Act now, but it's really for them to take an account of why this person remains in custody and has not yet been charged.
So what is provided for in any case where the judge of the parish court denies bail to the defendant who is arrested or detained without being charged, the judge shall specify the period within which the defendant shall be brought back before the court for the question of bail to be reconsidered. And these are the matters, because the court then is considering the grounds again, the stage of the investigation, the manner in which it has been conducted, whether further time would enable a charge, conduct of the defendant, reason given as to why the defendant has not yet been charged. And at the end of the day, if the charge is not done within a time-bound period, enabling time to build out the case so you can get the conviction in a proper case, then the person is released unconditionally. That is a scheme, you know.
Chairman, you know, we do not deny the effort that has been put in the intended legislation. We have our fundamental concerns remain. Bail before charge remains a fundamental concern for the human rights community. And what we regard as we don't have any access to the data or any empirical data that drives policy to know that these steps need to be taken, that as presented here. But we do recognize, Chair, the effort, but the divergence remain. And dissent is important in a democracy. It is critically important. That's how we keep ourselves safe.
Well, you know, Mrs. Harrison Henry, among the many reasons I like the law is the competition for better view to prevail. I would have thought that the human rights community would have been very pleased with this provision. Let me tell you why. We will agree to disagree at the end of the day. One is that in an appropriate case, a defendant who is reasonably suspected of having committed an offense will be arrested or detained. Not everyone is going to be so arrested, but in an appropriate case, such a person will be arrested and detained. And in many cases, the file will never be complete immediately. And the interest of justice requires that those who are truly guilty be found guilty. The presumption of innocence says you can't find him guilty without due process, because conviction comes only after a plea of guilty or a finding of guilt after a trial. And there are many steps to be taken between arrest and detention permitted by the Constitution for reasons and trial within a reasonable time, which would lead to acquittal or conviction. And so, in order not to have persons who can properly be restored to their liberty, so restored, and not languish in custody, I thought the human rights community would be pleased with it. Like I say, there are many other rights that are engaged, and the question is, how do you deal with them?
Chairman, bail before charge remains a sticking point and an area of divergence.
Your submission is that it's a matter best dealt with exclusively by the courts. That's what your written submissions provide. Yes.
we're saying that bail before charge it doesn't fall within the charter. We are saying that we have questions as to its constitutional soundness. And we understand, Chair, that there is divergence of opinion on this matter.
And we agree that some things are explicitly provided for and some things can be implied.
We agree, Chairman, as we have often done in the past. We agree to disagree.
To note, we celebrate the democracy. Parliament must pass laws for peace, order and good government.
And divergence, Chairman.
Absolutely.
It keeps us safe.
Absolutely. Trust that all the best for the season. Thank you for taking the time. Yes. All right, so we move to Mr. Jordan A. Jarrett. Mr. Jarrett is an attorney at law called to the bar in Jamaica and St. Lucia. He's the holder of a Bachelor's of Law degree with first-class honors from UWI Cave Hill and also a Master of Law from Columbia University with high distinction. Former judicial clerk with experience in comparative constitutional law and civil and criminal commercial dispute resolution across the Caribbean. Mr. Jarrett, thank you for taking the time. I note you say the views are your own, but you come on paper with impeccable academic qualifications. We look forward to hearing your views. You have the floor.
Thank you very much, Chair. Chair and members of the committee, it is indeed my pleasure to give these comments to this joint select committee. I think this is a great opportunity to foster dialogue between stakeholders, among stakeholders, in relation to this very critical piece of legislation that affects very critical rights that are enjoyed by all citizens and all persons within the locale of Jamaica. As the Honorable Minister and Chair said, I'm an attorney at law and I have a Master of Laws from Columbia University. And my experience, I would say, is in the realm of international and comparative law. And so much of my perspective is informed by that lens that I have. Chair and members of the committee, before you should have my written submission, which is dated the 6th of December, and it's 17 pages. And in that in that submission, I address 4 broad areas of substance in relation to the proposed act. I speak about the definition section, the general provisions, the pre-charge bail regime, and the post-conviction bail regime. I will very briefly address the first 2 points as they are of a little less substance than the other 2, and then I'll move on to more detailed discussions on pre-charge bail and post-conviction bail. Chair, I just want to also indicate I've seen some portions of the proceedings that have taken place before this committee prior to today. I've not seen all of them, so I apologize if I repeat points that have been made already or that have been already addressed by the committee. And as you already indicated, these positions, these comments are my own and not attributable to any organization. So I therefore also take the fault if for any errors that are in my submissions. So I'll commence with the definition section. And I'm sure the learned CPC is in a much better position to speak to the appropriateness of a definition of bail in the proposed act, but I note that a definition is not contained in the act. It's not in the the current bail act, and it's also not in the Constitution. And I think a definition would be helpful for 2 reasons. One, I think it would improve the accessibility of legislation to the relevant stakeholders. And I think my experience overseas has shown me it's actually quite interesting how many different groups rely on Jamaican legislation to develop their own policy. And since I returned to Jamaica earlier this year, I've had maybe about 6 groups contact me to clarify positions in Jamaican law. I think a definition of bail in the Act could improve the accessibility of the legislation. The second reason, which is a little more substantive, is that this proposed scheme essentially overhauls and rewrites a lot of our bail practices and codifies to a large extent practices that the courts currently engage in and standardizes them so that we can have a baseline across the board for essentially a uniform exercise of discretion to grant bail.
You think that's a good thing?
I think uniformity in application of law is a component of the rule of law, and I think it is necessary. And so to the extent that the memorandum of objects and reasons at the back of the bill states that that is a part of the purpose of the bill to essentially create some uniformity in bail practices in our courts and in those quasi-judicial officers who are exercising the bail discretion, I think it is commendable. But I think because of the overhaul and codification of overhaul of the bail regime and codification of current practices, I think that begets a definition. And I think the absence of a definition came to the fore in a relatively recent Court of Appeal case where the Court of Appeal in Lascelles Gardner and Horace Ellis essentially had to craft its own definition of what bail meant in the context of the legislation and using secondary sources. I think where Parliament has the opportunity to relieve the court of that responsibility of having to craft its own understanding, looking at the substance of a piece of legislation, it should. And this is an opportunity. Lascelles Gardner and Horace Ellis against now the King. And that was a decision on bail by Her Ladyship. Decision on bail pending appeal by Her Ladyship, Madam Nicole Foster Pusey, Justice of Appeal, or Judge of Appeal. I think I've referred to that. At page, that decision with the citation at page 7 of my written submission, at paragraph 7 rather of my written submission. So in short, my comment on the definition is that Parliament has an opportunity to relieve the court of having to do that, and it should take that opportunity. I'll go on to the general provisions. I only have a comment on one general provision, which is the provision relating to reasons for adverse decisions on bail. Now, Section 10, subsection 3 and 4 of the proposed act places a new obligation on all deciding officials, to record their reasons for adverse decisions on bail and make those reasons available within 48 hours. Now, I'm using the term adverse decisions on bail. That's not in the legislation, but it's clear from the list provided at Section 10.3, decisions to refuse bail, impose conditions on bail, vary bail, and revoke bail. Those are adverse decisions. Under the current Bail Act, only judges of the parish court have that obligation. And I think the expansion of the class of decision makers required to provide their reasons for adverse bail decisions should be welcomed. I think the reasons for decision are important to all persons against whom an adverse decision is made. Separately though, I noticed that the obligation under the section, this is now a point which I have not made in my written submission, but I noticed that the obligation under the section requires the decision to be recorded in the prescribed record. I would recommend that a standardized form be included in the legislation for the provision of reasons for adverse bail decisions. Now, the reason I've made this recommendation is we now have we're now seeking to incorporate a broader array of decision makers who are making adverse bail decisions. We're now seeking to incorporate them under that obligation to provide their reasons. Some of them are legally trained and some are not. Some are trained in being able to provide their reasons for the exercise of a judicial discretion in a very forensic manner, and some are not. And so I think providing a form could assist with the record of the reasons that is being made in relation to this section. I think also...
So just to say that the thrust of the new law is to provide standardized forms to
Yes.
make record keeping easier. And so the notice, which currently exists, but we have expanded it to look at the conditions, statutory declaration, recognizance, declaration, form of release.
Chair, I had a look at that form, at those forms at the back.
Yes.
And the first one, which is the notice, seems to my mind to have content that would lend itself to another form.
Well, yes. So by providing, so the scheme of the law, it looks at the conditions that may be imposed, and it provides for an application to have those conditions varied. It also provides for an appeal against a condition imposed. And that is why, if the appeal is in respect of conditions, then you can tick there, because you would have been told which of them. And then in respect of the grounds, we also indicated those. But proceed.
Chair,
Right.
just for my clarity.
But the submission is in
For my
so
clarity, Chair, which form were you referring to?
the appeal.
At which page?
Appeal.
So that's page 28?
33.
33. Right. The difficulty I have with that form satisfying the purposes I've been outlining is that this is a notice of appeal.
Right.
So this is a document completed by a defendant against whom an adverse bail decision has been made, who seeks to have that decision reviewed. I'm really suggesting a form for the decision makers, one, to assist those who do not have the training to express their reasons for refusing bail or making an adverse decision in a forensic manner. And two, also, which is something I didn't mention but should have, it allows for easy provision of the reasons in accordance with the section, because the section says the reasons should be provided within 48 hours. So a form would also assist with providing the reasons.
From the CPC, because what you are speaking to is part of our own contemplation. Madam CPC?
Yes, thank you. Just to clarify that this section, clause 10, provides for the form to be prescribed, so a form will be provided. What that means is prescribed by regulation, so regulations will be made setting out that form.
That's the response I was looking for, because the thrust of the new approach is to standardize the forms to make records easier, because all persons are to be provided with the records. So yes, that is it. So your submission, if we take it to the nth degree, instead of prescribing it, is to include it in the schedule as we have done here.
Right. I mean, that's clearly a matter for the CPC
yes.
and for the drafters.
Yes, it's a matter
but
for the drafters.
I am certainly comfortable once what I understand you to be saying is that I think Senator Bunting's mic is unmuted, so it's causing a...
Senator Bunting, we're hearing you. If your discussion is intended to... All right, good.
If what I understand the CPC and you to be saying, Chair, is that this form will be included at some stage, that's satisfactory to me.
Certainly, certainly. Clause 10(1), where a deciding official grants or refuses, appoints, because an adverse decision can be depending on which party. If the prosecution position is that bail should be denied and it is granted, the decision would be adverse to the prosecution's case. If the defense is that bail should be granted and it is denied, should be granted and it's denied, the denial is adverse. So it does provide for the record to be made in prescribed form and a copy of it served on the parties.
Thank you.
So that addresses your concern.
I'm very satisfied with that,
Yes.
Chair. Thank you.
Yes.
Chair, so while having interrupted the presenter, could I just express, and this is obviously for my own part, I know you're quite an interventionist, Chair, but I think it sometimes affects the flow of the presentation. And
say no more,
yeah,
Member Bunting, say no more.
so,
Mr. Jarrett, please make your presentation.
And I congratulate the young attorney. He's giving a great presentation. I'm enjoying it. And I would appreciate if you just allowed.
Understood. Yes. It's really where a point is raised and it is in fact addressed in the law. It's just a quick reference to it, but the discussion probably has gone on a little longer than it should. Yes.
Chair, I'll move on to my discussion on pre-charge bail, which I know has been the subject of very much spirited debate before this committee. I'll just outline the central features of the regime that are relevant to the points I'll make. Pre-charge bail under this new regime is available to persons suspected of committing offences listed in Parts 1 and 2 of the second schedule, which are punishable with imprisonment. It's available to individuals that are arrested or detained by the police but not yet charged because, quote, more time is needed in order to prefer charges. The question of bail must be considered within 48 hours of the detention by one of two deciding officers, either JP or constable at or above the rank of superintendent, who is neither the arresting officer nor an officer involved in the investigation of the offence concerned. And that person will decide whether or not to grant bail. If bail is not granted by that official, the defendant must be taken to a judge within 48 hours or 120 hours, as the case may be, as prescribed by the bill. If the judge denies bail, then they're required to specify a period thereafter for which the question of bail shall arise again for their consideration. And in any event, the bail can be refused to someone pre-charged for up to 6 months. The first thing I'd like to say, just having heard the submissions that were made earlier, is that, as you rightly identified, Chair, under the current Act and other pieces of legislation, justices of the peace and police officers have a power to grant bail. And I think an argument that is improper cannot be based on the fact that they have the power to grant bail, because what those provisions provide, that scheme allows for the spread of the consideration of the right to bail, essentially in vindication of a constitutional right, so that bail can be considered at the first reasonable opportunity. So, to the member, I don't quite remember who it was that also raised a concern about JPs and police being able to consider and grant bail or refuse bail. It's actually a protective measure, and it is not ipso facto inconsistent with the Constitution. Now, what we know from the case law is that bail is inherently a judicial function. The courts have always struggled to determine what functions belong to which branches of government. They've always had that difficulty. But in the case of bail, there's no dispute. Bail is a judicial function. And what is unconstitutional or unlawful inherently is to remove that power from the court and remove it entirely or undermine it or prevent it from being exercised. In the case where the power to grant bail is given to a JP or to a police officer, as is provided on the current Bail Act and other pieces of legislation, we are not seeing a removal of the court's power. We are seeing instead a temporary transfer with supervision by the court of the power to grant bail. So,
we're not supposed to disturb, but as a non-lawyer, can you repeat that for me again? I just want to make sure I get it right in my head. Can you repeat it for me? About the fact that you're not removing the power from the judge and it already exists as such. Can you just repeat that for me, please?
So under... let me see where I should go back to. No, that's fine.
Power may be favorably exercised exercised in favor of the defendant, supervised by the court. If it is denied, the power goes to the court.
So under our current regime and what is proposed under the current Bail Act is to have other deciding officers, JPs and police officers also decide the question of bail. They decide it preliminarily. And that's a preliminary assessment. And the court is not bound by that.
Just to say that the Constitution does not specify the court as the only entity before whom the person deprived of his liberty may be taken.
Yes, I agree with that.
Right.
So,
well, it's explicitly provided for in the Constitution.
So the short point is, remember, that what the law says is that we cannot take the court's power away to consider bail. So in cases, for example, like Adrian Nation against the DPP and the Attorney General, a case from Jamaica decided by the full court in 2011. Aliki Charles decided by the Judicial Committee of the Privy Council earlier this year. And the numerous cases from Trinidad, Barbados, and St. Lucia, you cannot take away the court's power. That is the court's power, and if you try to take it away, that's unconstitutional. Because
this bill does not do that. Point post-conviction.
So, again, and I'm hoping I can just finish this point to get the sentence out for the clarification of the member, with all due respect. The case law tells us you cannot take away the court's power. But what the case law does not say is that you cannot vest that power in somebody else to exercise preliminarily. And so that has been the long-standing practice, and it is a practice indeed intended to protect our right to bail and to have bail considered at the earliest opportunity. In practice, from my experience in criminal practice in Jamaica, many times a person will be in lockup for weeks before they have a court date. They would have been arrested and charged, and sometimes weeks pass without a court date. And so entrusting JPs and police officers with the ability to consider and grant bail actually allows them to preserve, what it allows our system to preserve that person's liberty at an earlier stage without having to wait for a judicial determination by a court. If the provisions of this bill were to transfer the court's power away, for example, in Trinidad, in their amendments to the Bail Act that were struck down recently by the Privy Council in Aliki Charles against the state, against the Attorney General. In that case, just like in Adrian Nation in Jamaica, the legislature said you cannot grant bail in relation to an offense of murder at all. That is completely stripping the power of the court to consider and grant bail, which is a very different matter, and that is unlawful because that amounts to legislative domination of the judicial power, and that is completely unlawful. But to vest that power in a deciding official with overall oversight of the court, I have not seen a judicial decision that looks down on that. But that was just a preliminary remark I wanted to make before I went further into my submissions. Now, I will speak about the absence of an entitlement to bail in relation to pre-charge detainees. This point, I'm aware from the news, has been dealt with by at least one person before this committee, so I will not belabor it. But the short point is, in my view, it is incongruous for the legislation to treat a person who is not charged with an offense in a more disadvantageous way than a person who has been charged with an offense. A person who has not been charged with an offense, and according to the terms of the bill, they haven't been charged because the file is so incomplete that the police are of the view that it cannot sustain a charge and they need more time. In my mind, I cannot reconcile how that person who has not been brought under the jurisdiction of the court by way of preferring a charge is treated less favorably than someone in respect of whom the file is so complete that the police decide that they'll prefer a charge to bring them before a court. And so that is my short point. I think that is incongruous.
But what does the use of the term shall mean? I mean, an entitlement does not have to be specified in exact term as an entitlement, but where it makes it mandatory for the consideration to be given.
Shall be considered, but not shall be entitled? Or is there a provision that you're referring to that I'm not aware of?
The CPC will answer in respect of terminology, but when we get to there. But continue the presentation.
And so
we're coming from a place where there is really no provision at all. So
right.
It's quite interesting.
So
but proceed.
That is something I'll address right now, which is something that Mrs. Harrison Henry spoke to a bit earlier, and you'll see my discussion on the relationship between pre-charge bail and the right to seek and obtain habeas corpus relief from at paragraph 12 onward, 12 and 13 actually of my written submission. Now, for the benefit of those who are not legally trained, the right to seek habeas corpus relief is something that inheres both, according to the common law, inheres both in every person and also in common law courts that are charged with protecting the right to liberty. What habeas corpus relief really is, and it is outlined in the terms of, I think it's section 267, which was read by a member earlier. It's the power of the court to call for someone to come to court, someone who has been detained, ask questions of their detention, and order that they be released. It's a common law right, and it has traditionally been complemented in England and in the Commonwealth by statutory provisions that seek to standardize the procedure for seeking habeas corpus relief. But to be clear, habeas corpus relief is not something that was created by any parliament. It is an inherent right that we all have, and it's an inherent power that the court has to consider whether to release someone unconditionally when they've been detained without a charge.
It's literally bringing the body of the person before the court.
Habeas corpus, yes. The Latin expression for bring the body, produce
Indeed.
The body.
Indeed, yes.
In my view, having considered the section 5 of the proposed act, which speaks to pre-charge bail, I'm really unclear on the relationship between pre-charge bail and the right to seek and obtain habeas corpus relief. Taken at its highest, the pre-charge bail regime allows for the court to order detention or to allow someone to remain in detention without a charge for up to 6 months. And then if an inter partes application is made, that 6 months can be extended for another 6 months. In my experience, habeas corpus relief can be obtained in as little as 2 weeks after detention. And that's in my experience. And while I was sitting here, I asked a colleague what was the shortest time in which she was able to get habeas corpus relief and get a person released unconditionally for who was detained without charge. And she said definitely far less than 2 weeks. So to my mind, we have two competing and parallel regimes. One is that the habeas corpus regime, which exists and has not been abolished by this Bail Act. It still exists and continues. That regime allows for you to go and seek the release of someone within 2 weeks, or on my colleague's account within less than 2 weeks of them being detained, to get them out. The pre-charge bail provisions allows for this person to remain in, those provisions allow for a detained person to remain under detention for up to 6 months, with the provisions being made for reviews and for an inter partes hearing to extend that. To my mind, I am not sure what would impel a person who has been detained to seek pre-charge bail when the right to seek and obtain habeas corpus relief is sitting there looking them in the face. To my mind, also, to the extent that the pre-charge bail regime can produce results that are inconsistent with the right to seek habeas corpus relief, I think that in and of itself requires further consideration by Parliament.
At the end of the day, isn't it open to the court to say, even in an habeas corpus application, charge or release?
It is open.
Right. And here, where it says that, just look
here
at the
where,
provision.
Chair?
I'll allow you to finish, where at 2, sub-clause 2, 5.2, is that where the judge will take into account the matters and would fix, if the judge is of the view that having considered the grounds, the stage at which the investigation has reached, the manner in which, and whether further time would be required to prefer the charge, says come back in 2 weeks, for example, and at that point, isn't it open to the court? Well, it is open to the court to give a determination specifically. What it does set is the time beyond which you may not go.
But what is interesting is that your scenario, let's flesh it out with facts. Let's say the judge is satisfied that the investigation is going nowhere and orders that release. What we have here is a permissive legislative scheme that says if that doesn't happen, someone can remain under detention for up to 6 months, renewable with an inter partes hearing.
But that is only a matter that the court would determine having regard to all the circumstances.
Right. So
and the court would be best placed to balance the interest of justice.
Right.
So that is entirely a matter for the court to determine, having regard to the goal that you're seeking to achieve and the things, including any other factor that is considered relevant. The court, isn't a court best placed to make that determination?
It is best placed to make that determination.
Right.
In my view, however, I fear, and I think reasonably so, that a regime that permits detention for up to 6 months at a time, renewable with an inter partes hearing and an order from a judge following that hearing, will in practice supplant the clear power of the court I guess it will in practice supplant the court's current predisposition to let people go on a habeas corpus application. I think, Chair, I see you're very eager to respond, but I don't know if I'm able just to finish and then we return to the questions. Thank you. In my submissions, Chair, I also make the remark that the obligations under pre-charge bail include an obligation not to interfere with witnesses, and I would just say that it could possibly, I invite the committee to consider including an obligation on the police to disclose who those witnesses are. I think I've seen very strange circumstances in which, because of a failure to disclose by the police certain things, that a defendant was prejudiced in terms of their enjoyment of a right to bail. And so I would consider, with an obligation to not interfere with witnesses, there should also be a statutory obligation on the police to disclose who those witnesses are. In my mind also, that may be in the round a little counterintuitive, because as it stands now, police have no obligation to say who is coming to them with information before they've preferred a charge. And so providing that information at the very outset, before a charge is preferred, may in fact have negative consequences on the conduct of the investigation itself. But in my mind, that might also be a reason to get rid of that stipulation altogether.
Well, I mean, I understand the recommendation where possible, but also you would have to balance whether the disclosure. So ultimately, the information has to be disclosed because the person has to respond to the charge. And the rules of disclosure are very clear, and they have evolved in an elaborate way in the courts. But one of the realities in Jamaica is who is providing the information to the police and the jeopardy that that person is put in at a certain stage. So an appropriate balance has to be struck. In an appropriate case, the witness may be known. And in other cases, they may have to be protected, just given very harsh reality. And the court would have to determine wherein the balance of justice would lie in making the determination.
I agree, Chair. Certainly, I can't disagree with that. In my view, though, if you have a statutory obligation not to do something, you must be provided with the facilities to not do it. And so I understand the comment and I recognize that danger, which is why I closed that comment in that way, which is that obligation itself poses a sort of circular danger to the administrator of justice altogether. But if a person is being required by statute not to do something, to refrain from doing something, they must have the facilities to refrain from doing so.
The point is well taken, and I think some language can be considered because we still have to guard against the real prejudice, the harsh realities in the Jamaican society, having regard to the type of offenders targeted for the type of offenses. But the point is taken.
Thank you, Chair. The last point I make on the pre-charge bail is that as the regime is proposed, now I recognize that this point is not a point that is determinative of whether the legislation should be adopted or not, whether it should be passed or not. It is more a matter of resource allocation by the government of Jamaica, which is obviously better placed than I am to make an assessment as to how its resources are allocated. But I think the pre-charge bail adds some work to the court's current workload. And so I just want to register publicly that, which I'm sure, Chair, you have considered and the relevant ministers have considered.
Crime adds so much more
work. And the level of crime adds to it too. The thing is, as it stands now, the courts are essentially bursting at the seams as the caseload increases with the increased incidence of crime. And so I would just recommend, as a matter of resource allocation, which is not relevant to the substance of the bill at all, that resources be allocated differently to accommodate this increased caseload that would be arising as a result of the pre-charge bail provisions. Under those provisions, under Section 5...
It goes both ways, because it can operate to prevent a matter from entering the court prematurely, where it is mentioned pending completion of file, mention a practice that currently exists and which the data throws up. I mean, steps taken within the court management system have reduced it, but it is still very much a feature. Some things are inescapable because sometimes you have to await forensic certificates, etc. But this can operate also favorably to ensure that matters are not stuck in court and you can't get to trial within a reasonable time.
Right. That consequence
so everything has two sides.
That consequence is definitely understood. I think right now having to sit as junior counsel in the bench of a parish court, waiting for 2 hours for a matter to be heard, is bearing on my mind because this piece of legislation also adds to the current caseload. But
provide for the matters to be dealt with in chambers, so that, and that provision is to ensure that the open court time is not competed with.
Well, I guess the chambers time has to be increased, which might possibly also affect the open court time.
But we can't get over process. Any point about resource constraint is a real point. We'll never be able to provide enough police to deal with the high level of crime rate. We'll never be able to provide enough courtroom to deal with the high number of cases before the court. So that, we have to consider it realistically. And it operates also to ensure that by the time matters go before the court, having regard to the other steps that would have to be taken, including settling representation, case management, getting a date, having regard to what else is on the calendar, if jurors have to be empaneled, all of those other processes, you can move as speedily as possible to trial without judicial time being taken up in the way that it is taken up now.
Chair,
case by case.
Chair, I wouldn't want us to be detained by this point because, as I mentioned, it does not affect the bill going forward. It is more a matter of which I am not best placed to comment. But I just wanted to register that concern on the basis of my experience in the parish courts.
Submission is that the pre-charge should be considered and there should be clarification between pre-charge and the right to seek and obtain habeas corpus.
No, I don't think I submit that pre-charge should be considered.
It's what's in the written paper.
That it should be considered?
Yes. Page.
Please point me to the paragraph.
Page 3.
Oh, what?
Yes.
Please forgive my imprecise language. I meant it should be reconsidered. At this point, I don't make many substantive arguments on the propriety of the pre-charge bail regime itself, other than for Parliament to clarify the relationship between pre-charge bail.
So that's a reconsideration.
Right, so
the
reconsideration
between the pre-charge regime and the habeas corpus regime.
Yes.
All right,
Thank
got
you.
you.
That is page 3 on the summary, the table. That's the first paragraph in the pre-charge. The insertion of an entitlement in the pre-charge stage should be considered. I think that's what I was saying, Chair, that the entitlement should be considered if it is to be there. But I'll just clarify as well. I say the whole scheme should be reconsidered.
Right. And that is primarily because of your analysis in respect of the habeas corpus entitlement.
Yes.
Right. And you're saying that it should be elevated to an entitlement, not merely in the form that it is provided for, mandatory as it is.
Yes.
I see.
And not mandatory consideration, not just mandatory consideration, a presumptive right to pre-charge bail if it is to be kept in.
Well, you see how you're taking it completely different from everybody else? No, because you are saying that, I think you are applying the right rule of interpretation. And you're saying once you're providing for it, it should not be lower than at the other stages, and in particular at the charge stage.
If it is provided for, because I know that my more learned colleagues have made extensive submissions about its propriety. If it is to be included.
I understand exactly what you're saying.
Thank you.
I understand exactly what you're saying. Is that you're saying, having read it as a right, impliedly so, purposively so, put it on the level that it is at other stage. Have I read you rightly?
I think so, Chair.
I see. Yes.
Thank you. I'll move quickly to my last set of points, which are in my written submissions reflected from paragraph 17 onward, on bail after conviction. Now, bail after conviction, we call that in practice bail pending appeal. It's where you file an appeal and for some reason you want the court to relieve you of your sentence of imprisonment for the time being until the appeal is heard and determined. Now, just to put this in further context, our Constitution does not expressly provide for a right to bail after you have been convicted, which is pending your appeal. Our Constitution is expressed in clear terms that says a person who is charged and is awaiting trial has a presumptive right to bail. But in my submission, and I'm sure this will engage the chair substantially, in my submission, the need for care in drafting provisions surrounding the right to bail pending appeal is heightened because this law and other laws, statutes, are the Court of Appeal's only source of jurisdiction to consider bail pending an appeal. And so whatever Parliament provides will be accepted as a matter of fact as a comprehensive scheme for what bail pending appeal will look like in Jamaica. And so there's there's need for great care when considering what those provisions will look like. Now, the proposed provisions have 4 main features. The first is that the applicant must have been on bail before they were convicted. The second is that the applicant must be appealing against conviction. The third is that there must be exceptional circumstances which warrant the grant of bail pending appeal. And the fourth is that the applicant was not convicted of a Part 2 Schedule 2 offense. I'll be commenting on 3 of these features. I'll start with the easier one, which is exceptional circumstances. Now, the threshold of exceptional circumstances is a threshold that has been accepted by Jamaican courts and Caribbean courts across the board and has dictated and has guided, in recent times with relatively little controversy, the grant of bail pending appeal. And so the inclusion of this standard into the legislation, in my view, is welcome. I would say, however, that for a very long time, the expression exceptional circumstances has been criticized in several places, in several courts across the world. So in 1975, in Jamaica, Justice of Appeal Graham Perkins, in this case, Regina and Rudolph Henry's 1975 case, he said, exceptional circumstances is a vague and indeterminate phrase from which no common statement of principle can be extracted.
Mr. Graham Perkins is known for dissenting judgment more than concurring judgment in the jurisdiction.
Thank you, Chair. I am advised.
All of us, myself had the benefit of being a judicial clerk. Is interesting. Is one of the justices who you are introduced with early. But if you go through, as I suspect you are prone to researching, look and see. Very interesting, but maybe it's the strength of the perspective that he held.
What I'll say is that his perspective is not unique. And up until this year, the United Kingdom Supreme Court criticized the phrase exceptional circumstances in relation to applications to reopen civil matters in the High Court.
What my research showed is that there is in the concerns raised is almost a begging for some guidance as to what would amount to exceptional circumstances from the policymaker's perspective.
And that's exactly where I'm going, Chair.
Because that's what my research shows.
I think courts are now saying, based on my research, as you have indicated, that exceptional circumstances does not, as a phrase, does not do much to assist the exercise of the judicial discretion. And I think it would be helpful in keeping with the Memorandum of Objects and Reasons of the Act, to provide examples in the legislation of what will or will not amount to exceptional circumstances. I say this well aware that courts have been crafting expressions of what exceptional circumstances means in various contexts. A few years ago, the Privy Council upheld a decision by Chief Justice Janice Pereira in the Eastern Caribbean Supreme Court, where she explained what exceptional circumstances meant in the context of a particular piece of legislation. Although, in the circumstances, the court seemed to be constrained to do so because there was no policy guidance, the courts have managed. What I say in this case is that our case law and case law across the Commonwealth is replete with examples of what will not amount to exceptional circumstances and what will. And especially in cases where bail pending appeal is being sought in the parish courts, I think the parish courts particularly can benefit from guidance as to what will or will not amount to bail pending appeal. What will amount to exceptional circumstances warranting the grant of bail pending appeal. Just for clarity also, my submission is not that Parliament should reinvent the wheel. I think the wheel is fine in terms of what the courts, in this regard, in terms of what the courts have said will or will not amount to exceptional circumstances. For example, the courts have said a strong appeal itself is not an exceptional circumstances. The courts have also said other things that I cannot remember.
Many other things.
Many other
But
things.
what
But my
is
short point
clear-
is that I think the legislation, in keeping with the modern judicial trends of seeking more clarity from a policy perspective as to what amounts exceptional circumstances, I think that should be considered in this case, having regard to existing principles that guide our courts.
Something we haggled with behind the scene, just to say. Well aware, the decision was taken that the court may be best placed in the circumstances of the particular case to determine based on the application before it. But the suggestion, and this is again part of the data, and it's interesting how different presenters have responded to it. Court has repeatedly said through, current members on the bench, that it is always helpful if Parliament were to specify what should guide the exercise of their discretion. And having done that, we have other presenters coming to say, oh, too much is put for the court's consideration. So it's really interesting, and that's why in my comments previously, I've said that when you make allegations around the law, come with a nuanced presentation, as you are doing actually, to do the analysis, because the bill has been considered. It doesn't mean that it doesn't mean we will not have diverging views on it, but every clause and subclause has been well considered. Member Rodriguez Campbell?
Yes, thank you, Madam Chair. And I'm really sorry to have to cut you again, but help me to understand something here.
Sure.
Bail pending appeal.
Yes.
And I know it's something that in the legal fraternity is known what that means.
Right.
And it's a very specific thing. And you know that you're talking about when the defendant appeals. Is that affected by the fact now that the prosecution can appeal a ruling? How is Clause 13 of the Bail Act, is it any at all as phrased for bail pending the determination of the appeal? I assume in my non-legal mind that it is referring specifically to an appeal from the defendant. But now in law in Jamaica, one of the laws I'm proudest to have been a part of, may I just add, where the prosecution can now appeal, 13 as worded, my non-lawyerly interpretation is that should also be considered.
What I would say, I would leave I would ask the chair to make a more fulsome comment on it, but I think not invariably, because that's not true. I think most times when there's a prosecution appeal, it is because the sentence was too low. And so generally the prosecution is asking for more.
Right.
So I think the appeal that is contemplated in the bail pending appeal or bail after conviction provision is an appeal by the person who has been convicted.
Right, which is what I think as well, but I'm just saying as worded.
Let me answer it quickly. So that you can appeal conviction and you can appeal sentence. These offenses are offenses that carry a sentence of imprisonment. So the court, properly speaking, and when interpreted against the right of appeal given to the prosecution, can only hand down a sentence of imprisonment as provided for, in the penalty for the offense. So that at the end of the day, if you are appealing, it's not a sentence, it's not a sentence of imprisonment that would be set aside to be substituted with a fine, for example. Your liberty, you are going to be deprived of your liberty. It's a conviction which could set aside anything, which would result in an acquittal that is going to be appealed. And also, as you have said, this is something that only the statute can create to give the court jurisdiction. There is no inherent jurisdiction around it because your situation changes after conviction. There is no longer any presumption because you're only convicted after you go through the due process. So that when we considered, so it's only certain types of offenses and the preconditions existing. What I gather from your comments is really to see if we can provide some guidance having regard to pronouncements from the court on what would amount to exceptional circumstances to help guide the exercise of the court's power.
And to do so in a way that does not
and
threaten
leave flexibility.
leaves flexibility and
Yes.
doesn't threaten the court's jurisdiction. So discretion. So I think
one thing that came to mind was like severe ill health, where someone may be better treated in a hospital without custody entirely. We did think through some of those circumstances that could amount to exceptional circumstances. And you're right, the fact that the appeal was not done within the time frame, and the court has provided guidance, and the court has indicated, though not explicitly, its preference to be aided in what would amount to exceptional circumstances in particular case. So
I think
point is understood.
With my non-existent experience in legislative drafting, I've proposed words that I think
very
can strike.
experienced drafter behind you, the Chief Parliamentary Counsel,
yes,
who in time will respond to the drafting issues raised,
yes,
and will, I have no doubt, ably respond.
So I think now the crux of my comments on bail pending appeal really, the nub of it really rests with the requirement that the appellant must be appealing against conviction. As it stands now, what that requirement does is that it says if you're appealing against a sentence only, you're not entitled to approach the court for bail pending appeal. Now, I don't want to sound crazy. I understand that it's an eminently reasonable requirement on its face, but I think there are exceptions that should be provided for in cases where the appellant appeals against sentence only. So, just to
tell you that was also considered, but we will consider.
Just to step back a bit, when a person appeals against their conviction, they're saying the basis on which you have sentenced me is itself faulty. All of that needs to go. And so therefore, they're challenging the basis under which they're being punished. When they're appealing against sentence, they're saying the sentence itself was bad. Either it was too much or the range of other complaints that can be made in relation to a sentence. When
have to bring the proceedings to an end soon because the Parliament will have to sit.
Yes, I'll be done very.
Madam Chair, I know, and I don't mean to overstep, but I'm very keen to hear what this presenter has to say, and I'm feeling a little bit rushed because I know the Parliament wants us out. Is it any at all possible for him to come back and finish rather than rushing through to the end? Because I'm a little slower than a lot of other people in here because I'm not a lawyer, you see? So I need more time to process what you're saying.
I think this last bit should take me about 5 minutes. Rush being...
Please proceed, and we'll see.
So what I invite us to consider is to look at the real purpose of bail. Yes, I agree there's no entitlement to bail post-conviction, but several courts across the world have made broad pronouncements on what bail really is about and what the purpose is in relation to persons under the jurisdiction of the court. I found yesterday a number of cases, and this one makes the point, I think, clearly. It is Ettridge, and I'm very happy to provide the citations for these authorities that I've been citing.
Contained in the submission?
It is not.
Yesterday would not have allowed you to revise it.
And my apologies for that. But it's Ettridge, Ettridge, and Hansen against the Queen, and it's a case coming out of Australia. And I'll just read this quotation very quickly. Our system of law is intended to ensure, so far as possible, that an accused person be given a fair trial and, if convicted, not be excessively penalized. Even so, trials can and do miscarry, and punishments more harsh than the crime and the circumstances of the convicted person warrant punishments more harsh than the crime and the circumstances of the convicted person warrant are sometimes imposed. Unfortunately, however, whether either of those events has occurred can only be determined in hindsight and with careful evaluation of the trial by an appellate court with the benefit of argument and the time to undertake it. In the meantime, conventionally, all concerned as a practical and legal matter are obliged to accept that the conviction and punishment have been regularly entered and imposed. But there are exceptional cases, and where these are shown to exist, the court may react by allowing bail to a convicted person pending the hearing of his or her appeal. The thrust of this statement is that bail is neither a punishment or a reward. That bail is offered, particularly in appellate cases, to prevent some grave injustice from being meted out against a convicted person. And I think I have a few examples that I've gotten from my colleagues at the bar that I think prove the point in relation to appeals against sentence. Example one, a person commits gross negligence manslaughter. Under our sentencing guidelines currently, if they are convicted of gross negligence manslaughter, have no aggravating factors or previous convictions, they're entitled to be given a fine. A fine will usually be imposed and the court will determine the fine. But in one case, a judge sentences that person to imprisonment. Now, under law, and our law in this case would include the statute and our sentencing guidelines and previously decided cases of the court that have consistently imposed fines in that circumstance, a person would not be entitled to bail if they seek only to appeal against sentence. But in that case, the law on all fronts says a fine is appropriate. And with virtual certainty, when that matter goes to the Court of Appeal, the Court of Appeal will set aside the conviction, will set aside the sentence of imprisonment. Let me not say with virtual certainty, but the Court of Appeal will set aside the sentence of imprisonment and impose the fine. In that case, though, you have a person waiting in prison for 4 years or 3 years, depending on the status of the transcript and the readiness of the DPP. They'll be in prison for 3 years, waiting for their appeal to be heard in the first place when they should not have been in prison at all. And that's what the law provides for in that circumstance. So in that circumstance, you see where there is something so exceptional about a case that bail really should be extended because they shouldn't be in prison in the first place. Example 2. A person gets sentenced to more time than the legislation allows. In my experience as a judicial clerk in the Court of Appeal of the Eastern Caribbean Supreme Court, I have seen magistrates on a file sentence someone. If the legislation says 5 years maximum, they sentence them to 7. And this is not a matter that is...
Our problem is the other way here in Jamaica.
But this is not... I want to say that this is not a matter that is necessarily unique to Jamaica.
The principle is taken where the sentence is unlawful by virtue of the term of imprisonment.
Exactly. And especially in circumstances where you have a delay in the hearing of an appeal and they might serve out what they could lawfully serve before their appeal is heard and their sentence formally commuted. And the last example is similar to the first one. So a fine is to be imposed and the judge orders imprisonment.
It could be where the court may want to suspend the sentence of imprisonment.
Right.
I understand the
examples. Just to make the point clear...
At the end of the day, there is an option where even though convicted and sentenced, they would not be deprived of their liberty. And they are not challenging the conviction but the sentence. Then you're saying a proper place should be given for that consideration.
And I take it further to say very briefly that a failure to so provide amounts to essentially legislative sanction of a person being treated in a way...
Go back to your starting point.
...that they should not be in accordance with the law.
Of what can be done post-conviction is provided for legislatively.
Exactly. And to the extent that that scheme is a comprehensive scheme regulating liberty Our cases across the Commonwealth are clear that a comprehensive scheme that is deficient and that raises an issue of the compatibility of someone's detention with the rule of law breaches the right to protection of the law. So, for example, you have a case, Attorney General and Noel Henry out of St. Lucia, Bisesa out of Trinidad, and Sipasad also out of Trinidad, where they review a comprehensive scheme, notice deficiencies, and come to the conclusion that the deficiencies in the implementation of the legislation and also in the scheme give rise to a breach of the protection of the right to protection of the law. So it is not just that Parliament has an unfettered domain in this regard. It is that it is still to be Parliament's power to legislate in this regard, because we're talking about a comprehensive legislative scheme, must still be pivoted against the right to protection of the law.
No issue with the general principle. But what happens post-conviction, where you're liable to imprisonment, has to be regarded as an exception. But the bigger point is taken. So even
Certainly.
the application of the CPSAD principle will have to look at
Certainly.
the exception.
Certainly.
Yes.
And just to tie that up, even though those are specific principles from that case, from those cases, there is a clear judicial trend to treat the right to protection of the law as more than procedural. And so, to the extent now we're seeing the Privy Council relying on the Maya Leaders Alliance case to flesh out what protection of law means in our circumstances, and in the Maharaj case that was recently decided, they are adding substantive elements to it in keeping with the substance of the rule of law.
I think the greater principle is that what the bill is seeking to do is to provide as comprehensively as possible for bail, matters relating to bail,
Yes.
by overhauling and codifying.
Yes.
And also having gone where we have not fully gone before in respect of what happens after the person has been constitutionally deprived of his liberty,
Yes.
with a view to bringing him to stand trial. Then you're saying on the other end of the spectrum, it should be considered a little more broadly.
Yes, and just for a comparative perspective, that provision that bail pending appeal is limited only to appeals against conviction doesn't exist in any other Commonwealth Caribbean country. It's not in Trinidad.
They don't have the kind of crime problem that Jamaica has either.
True.
And remember, you would have been found guilty beyond reasonable doubt. Anyway, the point is taken.
And we must vindicate the rule of law in the same breath.
The point is well taken. Well taken.
Thank you. I think
as you have rightly identified, the goal is to do something more comprehensively with this law than exists, having regard to the common law principles, experience in the jurisdiction, peculiarities. And though persons may not readily see how the realities and peculiarities have informed the provision, once practitioners look at it, they can pull it out and see.
And the last point I'll make very quickly in 60 seconds is that for the same reasons, I submit that bail pending appeal should not be made to rest on the type of offense that you were convicted of, particularly because exceptional circumstances and injustice that can be occasioned by them they operate across the board regardless of the offense that was charged and convicted.
Peculiarities in the Jamaican context determine those policy considerations, though. But thank you so much, Mr. Jarrett. Just to say quickly whether any member has any question, it was more interactive. I hope that those members listening on did not lose sight of it. I really want to thank you. Any question coming from any member? I don't see any hand raised. The level of your scholarship is obvious in the analysis and how you've raised the point. I want to commend you for taking the time to come.
Thank you.
Make the presentation.
I just wanted
the level of your scholarship is obvious in the analysis and how you've raised the point.
Go ahead, Member Bunting.
Thank you. And Madam Chairman, I would like to associate myself with your remarks and extend my thanks.
How obvious the level of scholarship is.
I really appreciate it.
Thank you, Member Bunting. Member Bunting has conveyed his gratitude.
Thank you, Member Bunting.
Yes.
And thank you, Chair and members, for facilitating my presentation today.
All right. So this now has really brought us to an end of the oral presentations that we will receive. The others will be considered in the form of a matrix. I know the House Marshal has been impatient of getting the floor to prepare for the sitting of Parliament. Thank you, Marshal, for your kind consideration. The time will not permit us to take the minutes, so we will roll that over to tomorrow. If we have no other business, then the date of the next meeting is tomorrow, Wednesday, December 14 at 10 a.m. in similar hybrid form. Before the adjournment is taken, any comment, anything? So tomorrow we will consider the minutes rolled over, and then we will also look at how we go forward with the matrix is to be done, and then we begin the clause-by-clause analysis and deeper response. And the CPC will give a little guidance on some of the matters raised. All right. Will someone therefore move for the adjournment?
So moved, Madam Chair.
The duo of Rodriguez, Campbell, and Charles. Very well. Thank you both. Yes.
Jamaica and its workforce are advancing quickly. Life-changing opportunities are arising. You need training and support. We are the Renewed Heart NSTA Trust, committed to providing new and emerging skills training and opportunities. Come to Heart. We'll help you claim your place in the workforce of the future.
It's Tuesday, December 13. In the headlines, the technical pilot for the National Identification System launched. Regionally, International Network of Women in Business kicks off in Belize City. Internationally, U.S.-Africa Summit kicks off in Washington. And in sports, we hear Jamaicans' opinions on which country will win the FIFA World Cup 2022. This is the news on PBC Jamaica. I'm Simone Absalom Gale. The technical pilot for the National Identification System, NIDS, was launched today, December 13,